Okay, I'm here today to talk about the 6.1 case study for 503 William Wood sports law class. I chose today Raspone versus Louisiana State University and Agricultural Mechanical College, Court of Appeals, Louisiana, First Circuit. History leading into the case: Joseph Samuel Raspone files this tort suit against LSU and its Board of Supervisors after he sustained injuries at Alex Box Stadium on the LSU campus. On May 28, 1990, Mr. Raspone attended an LSU baseball game that would determine if they would be going to the College World Series. The game had been rescheduled due to rain twice, and it had rained on the weekend before the game and also on the day that Mr. Raspone was attending the game, so lots of puddles around. Mr. Raspone arrived at Alex Box Stadium, made a stop at the concession stand, and then proceeded to his seat, which was down the left field line. The bleachers that were where Mr. Raspone was sitting had been brought into the stadium temporarily to accommodate the number of fans that were expected for this particular game, big game, determining whether going to the College World Series. Expected lots of people. On the way to the bleachers, there were puddles all over because of the rain on the paths, and fans were tracking water into the bleachers as they were going to sit down. Mr. Raspone was with some friends. They had taken their seats in the left field bleachers. After a short period, they decided that they would move, try to get some different seats, and sit in another area. As Mr. Raspone was leaving the bleachers, he stepped down on an awkward step and fell face first into the ground. The impact of the fall broke Mr. Raspone's ribs and ruptured his Achilles tendon. With presentation of the evidence, the trial court found the LSU failed to use reasonable care to provide a safe environment to the fans because of the bleachers and the way they were set up. They felt that there was evidence there to show that there was not a safe environment. Specifically, they ruled that the fall was caused by non-uniform steps of the temporary bleachers, which LSU was aware of but did not fix or have signs up or warn fans of the steps. The court assessed 90% fault to LSU, 10% to Mr. Raspone for inattentiveness when he was leaving the bleachers. Mr. Raspone was awarded $24,260.78 in lost wages and $80,000 in general damages. LSU appealed the case. They appealed the liability, causation, and fault allocations. Mr. Raspone appealed the ruling that he was 10% at fault, so they both appealed that they were not at fault. LSU appealed the liability ruling, stating that the non-uniform steps did exist, but it was because the temporary bleachers didn't fit together properly. When they put them together, there was a space between them, and that caused the non-uniform step. LSU also stated that even with the non-uniform step, that the bleachers were not found to be dangerous. They reported that there had not been any accidents in over 3 years of using those bleachers. LSU also felt that the non-uniform step should have been obvious to fans, including Mr. Raspone, as he was leaving the bleachers. The court ruled that LSU knew about the step and made no attempt to remedy the issue, not overturning the lower court ruling for this part of the case. So they stuck with the decision of the lower court because they knew about the existing problem. LSU then disputes the court's factual findings that the non-uniform step fall, contending that Mr. Raspone inattentiveness caused him to fall. They also contested that 10% of the fault was on Mr. Raspone. Mr. Raspone, in return, also disputed that LSU should have been 100% at fault for the accident and him 0% at fault. He felt that because of the way the bleachers were put together, it wasn't his fault that he fell. After looking at the facts, the court showed no error on the trial court and would not change the ruling, so they left 100% or 10% fault with Mr. Raspone and 90% fault with LSU. In looking at the appeal by both the plaintiff and defendant, the court ruled that there would be no more money awarded to Mr. Raspone. They felt like they couldn't change the ruling and make more money for Mr. Raspone or take away, make a lesser settlement for him. The appeals court did affirm the finding of the trial court and assessed $419.73 to LSU for all costs of the appeal. As an athletic administrator, in looking at this case, this is something that could happen at any facility that you play in, whether it be on the road or at home. It's important that that athletic administrators have a policy in place to evaluate and inspect your facilities and fix any issues that might be wrong with them. As the athletic administrator, I would want to make sure my coaching staff is also watching on a daily basis for their facilities and make sure that things are in good working condition. If not, they need to report that to head of maintenance, the administration, and myself as the athletic administrator. In looking at some of the facilities at our district where I work, we've had some issues with bleachers having splinters and boards that are broken. We've had people step through boards at our baseball facility, and we actually had to take those set of bleachers out and put different bleachers in so that we wouldn't have those issues. So it's important that we watch our facilities, make sure that we're going through the proper steps and through the proper channels to make sure that they're safe for everyone. And, you know, these type of cases would be limited. Thank you.